Thank you, Usha. As you have heard, Malaysia signed the instrument of accession to the Rome Statute on 4th of March 2019. However, 1 month later, the Prime Minister announced the withdrawal of this ratification. So, what is the effect or implication of the withdrawal? What is the ramifications of the pulling out? Where do we go from here? So to answer these questions and many more, we are honored by the presence of the 4 eminent speakers today, namely the Honorable Attorney General, Tuan Tommy Thomas, Tan Sri Dr. Rai Siatim, Dr. Gudel Singh Nija, and Surendra Anath, who will be the panelists in this public forum this morning.
It is critical that the Bar Council gets involved in this matter, because what's been forgotten is that ultimately the Rome Statute and anything to do with the International Criminal Court is very much a legal issue. It relates to the administration of justice, and therefore the Bar is the preeminent body to organize meetings and fora and to educate the public. So I'm glad that the Bar Council has done this. Perhaps they should have done this months ago, because there's always been a criticism of the government and the AGC that we don't communicate well or communicate at all. When it comes to Rome, I guess I can say neither did the Bar Council. So we are a bit late in trying to educate the people of Malaysia. And again, can I just start by talking about the history. Those of you who were either at the forum last week at the University of Malaya or were following it would know that Nur Farida, who was then in Wisma Putra, informed the audience of the critical dates. So can I remind this audience, and I went back and checked at my end because I wasn't so sure of the dates until Nur Farida mentioned it. So this is the chronology of what happened in Rome, with regard to Rome as far as Malaysia is concerned. And I'll just give you 7 key events. On the 17th of July 1998, that is 17th of July 98, Malaysia signed the final act of the UN Diplomatic Conference of Plenipotentiaries on the establishment of an international criminal court. We didn't have to sign it, but we signed it. So that tells you that in July 98, the government of the day was minded to join an international organization. Then on the 16th of April 2010, which is about 12 years later, the Attorney General's chambers objected to us joining Rome. That's 16th of April 2010. But a month later, the 27th of May 2010, Nazri, who was always a member of the Bar, I don't know whether he's back as a member of the Bar, Nazri Aziz, who was then the law minister, he announced Malaysia's readiness to be part of the ICC world. And that announcement was made by Nazri, and one assumes as a minister he has the authority to make such a statement. He announced this at an assembly of the rule of law in Uganda. So despite the AG objecting, the cabinet minister who represents the executive branch told the world that we are ready. And then about a month later, on the 11th of June 2010, the then Prime Minister issued a policy direction for Malaysia to agree to the statute, and that was following Israel's attack on the vessel, the Gaza Freedom Flotilla. So those were the events. And then, critically, the decision was made by the executive branch, the cabinet, that is the 18th of March 2011, when the cabinet resolved a sanction to the Wisma Putra, and Wisma Putra, the Ministry of Foreign Affairs, were asked to implement. Now I say this because there has been statements that, the Attorney General's chambers objected. That may be so, but the client, that is the government of Malaysia, makes the decision. Not all the advice of the AG is accepted, quite rightly. The political masters are entitled to reject advice, just as all of you practicing in the bar are used to your clients not listening to your advice and rejecting your advice. But it's a client's decision, not the lawyer's decision. And then what happened was, so that's March 2011. So although Wismaputra is asked to implement it, there's not much progress because AGC, the chambers, objects to this. And then 4 years later, a reference was made by the chairman. On 5th of August 2015, the cabinet instructed the AG's chambers to table another paper to ratify Rome. This was after the shooting down of MH17. So that was, of course, July. So in August, they revisited the issue. And according to my research, and this is the last event, the 7th event, on the 30th of November, which will be about 3 months later, the Attorney General's chambers refused to proceed on the matter. So to me, I'm surprised. I didn't realize that now as the person holding the position, I could refuse to act on instructions of the client, but that's what seemed to happen. So by a combination of factors, Rome was not acted upon. Now I give that history to explain why, to some extent, the government of the present government of which I serve as its legal spokesman, for some, one can explain why no one assumed that Rome would be turned into this political hot potato, having regard to the history, because it was the Barisan National Initiative. They were the government. The Prime Minister, the Law Minister, the Cabinet had all supported it, and certainly the Minister of Foreign Affairs. So in a sense, and of course the big difference was when I became AG, I immediately gave a legal advice that in my opinion, Rome, we should agree to Rome. So that would be, I think, perhaps the best explanation as to why we thought that we did not need to educate the public. And in a sense, that becomes clear when I very quickly go through the provisions, because from a legal perspective, if the Malaysian bar has, 20,000 members now, 19,000 members? 19,000 members. From a legal perspective, I think all 19,000 members will agree that there is absolutely no problem from a legal perspective, just law, pure law for Malaysia to join. It is one of those areas of the law where there is no grey area. It is just clear, black and white. It's like, since I'm addressing lawyers, it's like anybody now suddenly waking up and challenging the basic premise of the formation of a contract. So if somebody suddenly stands up and says, actually the contract is not formed by offer and acceptance and consideration, you turn around and say, what's wrong with you? It's so bedrock. All 20,000 lawyers in Malaysia accept that offer and acceptance equals a contract. So why are you questioning it? That is why, in a sense, you can understand why the guests whom the Bar Council invited, 5 or 6 of them, refused to come. Because it is so one-sided. It is absolutely incapable of any other interpretation. And I mentioned that because, as you know, the Rome Statute, and I'll just take 3-4 minutes because all of you already surely know about it as lawyers. Article 1 of the Rome Statute, of course it's all on the website. Article 1 tells us, so that I'll take just 5 minutes to explain to you why I say it's incapable of being interpreted any other way. Just not possible. And why do we say that? Because Article 1 of the statute says that the ICC shall have power to exercise its jurisdiction over persons for the most serious crimes of international concern. So, what does it involve? Most serious crimes of international concern. And since I'm talking to lawyers, you know, every word there matters. Most serious crimes of international concern. Okay? Then it's elaborated on in Article 5, which is the jurisdiction. They repeat it. limited to the most serious crimes of concern, but this time they add on to the international community as a whole. Why did they add on the words as a whole? That tells me, as a draftsman and somebody who has spent my entire career defending or attacking legislation, so how do we interpret it? Because of the words as a whole, it suggests that it must be something that's so terrible that the world's conscience is triggered, like the Holocaust or Rwanda or Darfur. So if it's a little regional thing, it may not trigger, because it's international community as a whole. And then they go on to specify 4 crimes, and 4 crimes only. Because just in case there's doubt that you could extend the crimes, that's removed. And the 4 crimes are genocide, crimes against humanity, war crimes, and the crime of aggression. So that is why I'm confident that the moment any lawyer, anybody who's legally trained, reads those 4 crimes, he will stop and say, look, what is this problem? Because Malaysia we have never been accused in our history we can go back to the Portuguese and to the Malacca Sultanate, except perhaps during the Japanese occupation in the Second World War, when they were quite barbaric, but still then there was not much stories or historical facts of killing of thousands of civilians by the Japanese. So any Malaysian lawyer will say, look, these crimes are alien to the laws of Malaysia. And surprise, surprise, they are not even offences under Malaysian law, because as you know, as lawyers you know, you can't have a common law offence. You must have it in the penal code or any other act, MACC Act or whatever. It has to be statutory. Because these were non-existent crimes, which never troubled anybody, these crimes don't even exist. As we speak, they are not offences under the laws of Malaysia. So if they are not offences under the laws of Malaysia, what is the problem? What is the problem? And of course, if we join ICC, we have to make them laws of Malaysia. We have to domesticate it, like the Vienna Convention on Treaties. We have to have, in fact, the ICC bill, which is ready, makes all these laws of Malaysia. So I will just very quickly say, Article 6 is on genocide. If we join, our act will have a section which reproduces the wording, every word. So genocide, so I just to show you why we don't have to be worried about genocide in Malaysia, means any of the following acts committed with intent to destroy in whole or part a national, ethnical, racial or religious group. So you must have intent to destroy in whole or in part a national, ethnic, racial or religious group. Does Malaysia ever do those things? And if you are thinking about doing it, well, we shouldn't. So that's how extreme these laws are. So why are we as a legal community not accepting them as offences under the laws of Malaysia? That should be the legal question that all of you are qualified to answer. So when it's so clear, then I won't read the rest of all. The other 4 crimes also are defined here, and we have to follow it to the letter. So what will happen is, if there was an ICC bill, and there still can be, the ICC Act will have, I just pick a figure, a number. So Section 6 may say genocide. Section 7 may say this. Section 8 may, but it will be identical. So it becomes domestic law of Malaysia, and then we can charge. But we haven't reached that stage. And then can I just very quickly, just go 5 minutes more. Any lawyer looking at it will say then the domestic crimes which trouble Malaysians, things like murder, kidnap, rape, or whatever other serious crimes which occurs on a daily basis or often in Malaysia, if that happens, ICC is not triggered, because they are domestic crimes and Rome, nothing to do with Rome, and those crimes would be charged if the police investigate and the public prosecutor decides to charge. They will be charged under the ordinary criminal law of Malaysia, in the ordinary criminal courts of Malaysia. It has got nothing to do with ICC. So therefore, it's abundantly clear, beyond any argument, that ICC has a very narrow and limited jurisdiction. And then of course, I'll go very fast, there's also the doctrine of complementarity, which means that if we make these 4 offences offences under the laws of Malaysia, and something happens, a genocide episode happens in Malaysia in 5 years' time, then again it's not the end of the world, because the burden is on the Malaysian authorities to investigate. So our police must go and investigate, complete their investigations, and pass the file to the public prosecutor, who then charges. And if the public prosecutor charges in the courts of Malaysia, that's it, you've done your duty. So you ask yourself, why can't they do that? Has anybody been accusing the AGC or the Public Prosecutor's Office for the last 200-300 years as a general statement? Are they not enforcing the law of Malaysia? Yeah. I mean, there may be errors committed by myself and my predecessors on whether we charge the right person or wrong person, right offence or wrong offence. Fine. Those are subjects of discussion among the lawyers. But never has there been a criticism that the Public Prosecutor's Office has abdicated his important jurisdiction of charging. So there's no fear that a public prosecutor after me, or many public prosecutors down the road, will not charge anybody in the courts of Malaysia. And if that happens, ICC has got nothing to do with it. And then I end by saying that why then was this so politicized? And the answer is, of course, always politicized by bringing in race, religion, and royalty. Here, they brought in the doctrine of sovereign immunity and tried to confuse the Malaysians. And unfortunately, millions of Malaysians may still remain confused about the immunity. But can I just say that although the 9 rulers enjoyed immunity during the British days and in Merdeka, in our federal constitution, in 1993, by the way, that was a Barisan National Government in 1993, which amended the constitution and took away the sovereign immunity of the rulers. So from 1993, the 9 rulers do not enjoy any kind of immunity. Of course, you know the establishment of the special court, Part 15 in the Constitution, and as a result, and you know that the rulers can be sued personally, both for civil proceedings, and I think there have been 1 or 2 instances, and criminal prosecution. So if the rulers are today, for the last 25 years, no longer enjoying sovereign immunity under domestic laws of Malaysia, what is the fuss about? It's total dishonesty. Total dishonesty, because to say that immunity is affected presupposes the existence of immunity. Immunity disappeared in 1993. So that is another massive lie. So I end in my 20 minutes. As a barrister, one should be able to keep time. So my 20 minutes is up, which is why the watch is here. To all you lawyers, I'm waiting with glee, waiting with a bated breath to hear a legal argument as to why the Malaysian law cannot accommodate ICC as a matter of law. The politics of it and all is something else, but as a matter of law. And since we are all lawyers first and foremost, we are all in the legal profession in the wider sense, can we have a legal discussion as to why Rome cannot be done? So I end by saying, in my opinion, as a matter of law, Malaysia should join Rome. The decision finally is for the political masters. So you know, I've said that throughout. My advice has been, I'm a lawyer, my advice to my client, the government of Malaysia, is there are no legal objections to joining Rome, but the decision to join or not join is not mine. I'm not the cabinet, it's a political decision. So I can't explain to you why the government decided to change its mind. I don't know. But if they give us instructions, they can always revoke their decisions. If they revoke that decision and ask us to support it, we will. The bill is nearly ready. So as lawyers, we are happy to accommodate. And of course, the last thing is, what is possible is for us to do it in stages, for us to pass the ICC Act. And as you know, as lawyers, we are used to different sections of the Act coming into effect at different points of time on Gazette. So we could have a situation where we pass the ICC Act straight away, making these 4 offences under the laws of Malaysia, criminalizing them under the laws of Malaysia, but defer when it comes into effect internationally, or when we join. So there are many, many creative ways of solving it. So thank you very much.